Just when I think I'm caught up with the Gloria Satterfield news, another bomb drops. This time, it's a memorandum. Not just any memorandum. This memorandum comes with 19, yes, ladies and gentlemen, count them, 19, as in A through S, action-packed exhibits from Gloria's Sons attorneys Eric Bland and Ronnie Richter. This monster of a memo weighs, yes, I did put it on my cooking scale, and it weighs 20.5 ounces. And this is the cheap paper. Anyway, this massive memorandum with its 19 delightful exhibits is packed with information that we're going to digest together today. On this season of The Other 55%, the trial that consumed the entire true crime community and beyond.
And I could see his brain on
generating millions of dollars in fees. That was not enough for you.
I know you have to see Paul and Maggie during the night times when you're attempting to go to sleep. I'm sure they come and visit you.
All these people on these two exhibits, these were real people that needed this money, is that correct?
I'm sure they did.
somebody going to check them.
Yes, sir. They've already checked them.
They did check them?
Yes, sir.
It's official that they're dead?
Yes, sir. That's what it looks like.
Oh, and it might not have been you. It might have been the monster you become.
The murder trial is over, and the next trial for his financial crimes is about to begin. We've heard the number of indictments. Let's go beyond the numbers. As Creighton said, these are real people. Let's hear their stories on Murdaugh Money, the Victims with Cassidy O'Connell. I will admit that I heard some criticism about the way this document is written, and honestly, it starts off very off-putting indeed. It feels loose and informal for a legal document, and though it's not my style, I won't begrudge that. My thing is it's centered on golf lingo, something I know nothing about, so yeah, I had my dictionary open while I got through this. Starting from the caption, I was surprised to see Chad Wetzendorf named as a defendant. I had heard something in his deposition and mistook it to mean that because he had paid back his fees and agreed to cooperate, that he wouldn't be named in any lawsuits. I'm happy to see I was wrong about that. I'll never forget him claiming that he, as a bank vice president, didn't understand the word fiduciary. No, his act was not convincing, and if he honestly didn't know the meaning of that word, he truly has no business serving in his position, in my opinion. But here he is, a named defendant. Also in the caption, notice that in the reference to Alex's motion for relief under Rule 60B, and if you followed me, you know I did a video about this a few weeks ago, I was really puzzled that they had taken this route. And I will link that video in comments if you missed it, so that you can click on it and watch that. But at the time, I felt this was an odd argument, since Alex was the one changing the stories. And I felt it was odd that they were falling back on his completely opposite story as a method to work in their favor, which felt to me like a complete abuse of this rule. I mean, after all, if that was allowed, what an easy way for criminals to turn things back into their favor. Just lie, hold things back, and then later say, hey, you know what, I lied before. I thought it would help me, but it didn't, so now I want to tell you the real truth, because it suits me better now. And I stand firmly with what I said then. Shenanigans. And this is basically what Bland and Richter say, albeit with an abundance of golf terms. So let's get into this. In the second sentence, it asks, may I have a mulligan? Now the Irish in me wondered what stew had to do with any of this, but after reading on, I realized this is a golf term, and for those of you unfamiliar as I am with this, it means basically, a do-over or a second chance with no penalty, and it's usually for spectacularly poor or embarrassing shots, and these are often considered handicaps. They're not for tournaments, but only for like casual play, and it's usually for new players, not something you would expect from longtime players who are supposed to be the best. We'll get into these hooks and slices later, But they add that Team Murdaugh stumbled late on the judicial first tee with a small bucket of balls and with the apparent attempt to fire shots until they finally hit the fairway. So basically, he's accentuating how, just like I said, Team Murdaugh had a spectacularly poor shot. And now they want a free do-over, or, as they go on to explain, because I committed fraud on the court, I'm entitled to be relieved of my confessed judgment now. I mean, this is nuts, even for Team Murdaugh. And they go on to state that this memorandum will expose how all of these have needlessly wasted the court's time and further victimized the Satterfield family. If you're a regular here, you know that I'm all about the victims, and so is this channel. So you can see why I'm so excited about this memorandum. On page 2, we get to a whiff. So it was back to the dictionary for me. So a whiff is when the golfer attempts to strike the ball and misses it completely. So kind of like a strike in baseball. So in this case, he presents my same argument that you can't use your own fraud as a basis for this relief. I'm not going to take any time on these legal citations because there are so many, and these are here to be used as legal precedent to support their arguments in the hopes that the judge will decide in their favor. So it does get kind of repetitive, but I do admire how very many that they've cited here, and I like the sentence that Alex seeks equity from the court, yet he has not discharged equity, and cites the doctrine of unclean hands, which basically says that unclean hands preclude a plaintiff from recovering in equity if he acted unfairly in a matter that is the subject of the litigation to the prejudice of the defendant. So you have to come with clean hands when you're asking for equitable relief. So coming and saying, "Oh, I lied before," is not coming in with clean hands. It then goes on to say in the footnote that although his previous statements were made in sworn affidavits, depositions, and under oath in court, none of what he's claiming now has been presented in this official way. Page 3 continues with the points that he admitted to a years-long pattern of drug-induced theft and dishonesty, but we should believe him now, with the footnote reminding us that what Alex is claiming now would mean he committed fraud, not just lied, but committed fraud on 3 courts, including before Judge Newman, before Judge Hall, and even the South Carolina Supreme Court with his previous story. So how he thinks that this is better it's just beyond logic. But in this twisted logic, he's trying to say if he lied about the dogs, then the insurance never should have paid. So it doesn't matter that he took the money. Not only that, but he should just get to keep that money, and that this Rule 60B says so. I mean, what do you guys think of that? I'd love to hear in your comments. So where I say shenanigans, BlandRichter gets much more colorful with words like nonsensical, depravity of mind, and sheer balderdash, and I agree. And that brings us to slice, another golf term meaning a golf shot which the golf ball curves dramatically in flight from left to right, or opposite if you're a left-handed golfer. So, not like the curveball in baseball where it's actually a great tactic against the opponent, this is a ball that doesn't go in the intended direction. The doctrine of judicial estoppel comes into play here, meaning that just as I mentioned earlier, a party cannot adopt a position in conflict with one earlier taken in the same or related litigation. When a party has formally asserted a certain version of the facts in litigation, he cannot later change those facts when the initial version no longer suits him, which is exactly what Alex is attempting to do here. Now there's factors that make this a reality. Let's consider what these factors are and see if they apply in this case. Number 1, clearly inconsistent. Check. It's just an absolute about-face in his story. Number 2, whether the party has succeeded in persuading a court to accept that party's earlier position. Check. 3, whether the party seeking to assert would derive an unfair advantage or impose an unfair detriment on the opposing party if estoppel is not applied. Check. Absolutely. So it falls well within the standards for judicial estoppel. Page 5 digs up a little nugget of fact here too from Alex's motion, page 22, that said that Murdaugh lied about his own liability. Yet, as the footnote mentions, Alex actually negotiated for a release that stipulated that he had no liability. Footnote reads, at his murder trial, when he supposedly was telling the truth about his prior thefts from clients and lies to them, Murdaugh never testified that the dogs didn't cause Gloria's fall. In fact, Assistant Attorney General Creighton Waters elicited testimony from Tony Satterfield that Murdaugh had confessed judgment to the family for $4.3 million. No one from Team Murdaugh objected or took the position that the confession was a legal nullity. Obviously, they thought it was beneficial at that time to have the jury believe that Murdaugh had made restitution to the Satterfields when they accepted the testimony without challenge. And that was very well said. This brings us to Exhibits A and B. Now, we spoke of these extensively in previous videos that specifically dealt with Chad Wetzendorf's deposition. These are the documents that Corey Fleming requested and Judge Carmen Mullen agreed would be kept unfiled in court so that Mark Tinsley would not be aware of the court winnings in the then upcoming boat trial, which is now upcoming once again. But in both Exhibit A, the petition for approval, and Exhibit B, order approving settlement, the dogs and/or Alex's liability are not even mentioned. And the order even goes on to say, it is denied by the parties to be released that the injuries and subsequent death suffered by the decedent were the result of any negligence or recklessness of any released party. So this is definitely a good point. How do you lie about being liable for something that in the documents say you were not liable for it? But here it reads at the bottom of page 22, Mr. Murdaugh lied about his own liability for Miss Satterfield's death to fraudulently obtain insurance proceeds to perpetuate his severe opioid drug habit. Yet the documents say he had no liability. This brings us to Exhibit C, which is the release that's been prepared laughably by Chad Wetzendorf, who claims that he was not under any influence or inducement by anyone when he prepared these documents, that in a deposition he claims he didn't understand and knew nothing about. But so far, none of these three most essential documents mention dogs as the reason for the payout. So Team Murdaugh's point seems moot. But let's go on, because they covered every little inch Alex could possibly try to wiggle out of, in my opinion, because now we're going to listen while Maggie and Paul speak again from the grave to ensure justice is served. And that's found here in Exhibit D, my favorite exhibit in this pack so far, because it has so much information in it that I didn't know previously. I'm going to read quite a bit out of it, so get comfy and relax like it's Cassidy story time. This is a comprehensive report that's been prepared by R. Scott Wallinger Jr. of Collins Lacey Attorneys at Law, and it is addressed to Caitlin Christ and David Patrick. It reads, Dear Caitlin and David, I hope you are well. Please allow this correspondence to serve as my second comprehensive report in the above referenced matter. It will follow the requested reporting format. New information since my last report is noted in bold type. Then it goes on to say, I recently obtained medical treatment records for decedent Gloria Satterfield. Depending on whether time permits and whether the claim does not resolve, it would be useful to have an expedited record review performed by a physician with expertise in emergency medicine and/or internal medicine to evaluate whether Miss Satterfield's health on the incident date played a role in her fall down the stairs. I have not yet placed the dog trainer on notice of a potential contribution claim by Murdaugh. Mr. Murdaugh considers that improvident. I therefore want to discuss that with you further. Claimant counsel has made a policy limit settlement offer with an acceptance deadline of November 12th. We need to decide how to respond to that demand and whether to seek enlargement of his imposed deadline. Now it goes into part 2, the executive summary. Decedent Gloria Satterfield worked as a contract housekeeper and domestic assistant to the insured, Mr. Murdaugh and his family. Mr. Murdaugh is a successful personal injury attorney in Hampton, South Carolina, and he owns a second home on rural property in neighboring Colleton County. On the morning of February 2nd, 2018, Satterfield drove alone to that Colleton residence to see Miss Murdaugh and to pick up a check in payment for Satterfield's past services. Satterfield walked alone up the front brick steps of the house and allegedly fell backward down the steps due to being pushed or tripped by one or more of Murdaugh's 4 pet dogs, which were roaming free at the time. No one witnessed Satterfield's fall. Mrs. Murdaugh was inside the house, heard a great commotion on the front porch, came out the front door, and found Satterfield lying on the steps, bleeding from an open wound to her head. Satterfield told Mr. Murdaugh, who arrived soon after, that the dogs had tripped her up. Satterfield made no other statement to any witnesses about the involvement of the dogs. Satterfield told medical staff at a hospital later that she did not know how or why she fell. Satterfield was airlifted to a hospital in Charleston, where she was admitted for treatment of multiple rib fractures, a pulmonary contusion, and a subdural hematoma. She had surgery for the rib injuries. The subdural hematoma was inoperable. Satterfield initially showed improvement, but then began a decline and was placed on a ventilator. She contracted pneumonia, had a heart attack, and lost pulse, was revived but left in a deep coma, and her family elected to stop life-saving measures. She was moved to hospice and died on February 26, 2018. Satterfield incurred medical treatment charges in excess of $650,000. She is survived by 2 adult sons, one of whom is mentally disabled. Her estate and both sons are represented by counsel who has advised of his intent to bring a lawsuit against Mr. Murdaugh. The law applicable to this matter provides that the owner of a pet dog is strictly liable where the dog jumps on a visiting guest and causes injury. Liability is probable. Part 3. Relevant background facts. The insured Alexander Murdaugh is a third-generation lawyer practicing with his family's law firm in Hampton, South Carolina. The firm is a preeminent plaintiff-only practice. The firm and its partners have a favorable reputation in that area of the state due to the firm's experience and influence and goodwill created in the county. The firm also has an office in Colleton County. Mr. Murdaugh's primary residence is in Hampton. Murdaugh and his wife own the second residence in nearby Moselle, which is in a rural part of Colleton County. That residence is typically used by them on weekends and holidays and includes several hundred acres of land, much of it swamp, used for hunting. That residence's address is 4157 and 4147 Moselle Road, Islandton, South Carolina. At the time of the incident in February 2018, Mr. and Mrs. Murdaugh were staying at the Moselle residence most of the time. Gloria Satterfield worked for 20 years as a housekeeper and personal assistant to Mr. Murdaugh's mother and to Mr. Murdaugh and his wife Maggie. There was no written employment agreement, and Satterfield could be considered an at-will independent contractor of Mr. and Mrs. Murdaugh. The Murdaughs paid Satterfield, get this, $10 per hour. That just, wow. Anyway, Satterfield was not considered a full-time employee of the Murdaughs, and no taxes were deducted from her paycheck. Satterfield would do household chores, babysitting of their children, run errands, and act as a server at parties hosted by the Murdaughs. Satterfield spent considerable time with the Murdaugh family, and as is common in South Carolina, was considered part of the family in a loose sense. Satterfield had no actual kinship to the Murdaughs, however. Satterfield had no other employment. Mr. Murdaugh considered Satterfield to be very trustworthy and dependable. Satterfield did not wear glasses or contacts, but did use reading glasses for reading. Satterfield was widowed and lived in Furman, South Carolina, with her adult son Brian, who has mild retardation and is not self-reliant. Satterfield's other adult son, Tony, is a registered nurse in Beaufort, South Carolina. Tony is the personal representative of her estate, which we know that changed later to become Chad Wetzendorf. The Murdaughs own 4 pet dogs, several of which have been to obedience training and have been trained for hunting and sporting activities. Bubba is a 6-year-old male Labrador retriever, not neutered, and described as affectionate and calm. He had been to hunting and obedience training and is obedient. He weighs around 90 pounds. Veterinarian records indicate receipt of annual shots and annual exams. Bourbon is a 1.5-year-old female chocolate Labrador retriever, described as hyperactive and difficult to command and control. She had been to hunting and obedience training. She weighs around 55 pounds. While veterinarian records are brief, the records indicate regular exams and prescribed heartworm preventative medicine. Blue is a 1-year-old male Labradoodle and is Bubba's son, described as hyperactive and constantly escaping from his kennel, and difficult to command and control. He weighs around 65 pounds. And finally, Sassy is a 6-month-old female German short-haired pointer puppy. She was acquired in January and has not had training. She weighs around 25 pounds and has a calm disposition. Mr. Murdaugh described that normally Bourbon and Blue would be kept in dog kennels at the property and did not roam free. The property has an electric underground dog fence system to keep the dogs close to the house. Murdaugh described that whenever all of the dogs were out of the kennel and in the presence of any people, the dogs would approach the people in a friendly, normal, and sociable way, and they tended to compete with each other for attention of people. He described that if someone showed praise or attention to one dog, the other dogs would get jealous and escalate efforts to gain the person's attention. Bourbon was sent to Brett Lawson, a dog trainer in Jasper County, for obedience and hunting training. A goal of the training was to calm the dog down. Murdaugh felt the training was helpful. While dates are unclear, Bourbon was picked up from obedience training a day or just a few days before the subject incident. Below is a photograph of Bourbon. On the incident date, Mr. Murdaugh left from the Moselle house to go to work around 8 a.m. His son Paul, aged 19, was inside the house. His wife Maggie and his son Paul were inside the house. A property caretaker, Ronnie, was at the property but not in view of the house. Satterfield drove to the house to pick up a paycheck, parked, and apparently was walking up the front steps. Below are two photographs of the subject stairs at the front. I have interviewed Alex Murdaugh, Maggie Murdaugh, and Paul Murdaugh. Alex Murdaugh. Alex left the house that morning at about 7:45 to go to his office in Hampton. He had been at work about 2 hours and got a call from his wife Maggie, who said that Satterfield was injured at the house. Alex drove back to the house. He arrived before EMS did. He found Satterfield sitting on the brick landing at the base of the steps. She was semi-conscious, knew who she was, and had blood on her head and face. There was a pool of blood on the brick landing. Satterfield indicated something to him about the dogs tripped her up. EMS arrived and took over care. EMS debated whether to have a helicopter land in the community somewhere to transport Satterfield to a trauma center. EMS decided to drive Satterfield to Colleton Medical Center in Walterboro, South Carolina, about 30 minutes away, to put her on a helicopter there. Alex followed the ambulance to Walterboro. He was given Satterfield's purse just before she was put on the helicopter. Alex drove back to his house in Moselle. He attempted to call and text Satterfield's brother, but did not speak with him. Alex told me that he had heard from one or more of Satterfield's relatives, he cannot really recall, was that Satterfield had reported that the dogs tripped her up. Alex never visited Satterfield in the hospital. Alex attended Satterfield's funeral. And now we hear from Maggie. Margaret Maggie Murdaugh. I interviewed Maggie Murdaugh by telephone about 2 weeks ago. Maggie described that morning of the incident. She was in bed, asleep. Her son Paul was asleep in his bedroom. Maggie expected Satterfield to arrive at the house at some point that day. The 4 dogs were outside the house and were seldom let inside the house. The chocolate lab Bourbon had just been picked up from obedience training a few days before. 2 employees, Ronnie Freeman and Travis Martin, were on the property working, but were not near the house. Maggie heard the dogs barking in an unusual tone, as if something had happened. She went out the front door and found Satterfield lying on her back, head toward the bottom of the steps, with a bleeding head wound. Satterfield was not carrying any objects. Satterfield's eyes were open. She was conscious and was mumbling gibberish. Satterfield did not know what happened. Maggie shouted, "Oh my God!" The 4 dogs were walking near Satterfield. Maggie's son Paul came outside. Ronnie Freeman and Travis Martin came up to the house. Maggie called 911 and Travis was sent to the highway to direct EMS when they arrived. No one rendered first aid before EMS arrived. Maggie put all the dogs inside the house. Alex Murdaugh arrived before EMS. Colleton County EMS arrived and took over care of Satterfield. Satterfield told them her name and said the current president is Bill Clinton, which naturally this was very long incorrect. So it shows us her state of mind at the time. Maggie tried to call Satterfield's son Tony and Satterfield's sister Ginger. Tony called back and was told Satterfield was injured and being taken to a hospital. EMS initially planned to drive Satterfield to a recreational field a few miles away for a helicopter to land and transport Satterfield to Charleston. They decided not to do that, and instead EMS drove Satterfield to Colleton Regional Medical Center in Walterboro, South Carolina, about 30 miles away, to meet a helicopter there. Maggie and Alex drove separate vehicles. Maggie drove straight to Trident Hospital in North Charleston, where Satterfield arrived and was admitted. Maggie met Satterfield's relatives Tony, Sandra, another sister, and Ginger at the hospital. Maggie saw Satterfield in the ICU. She was sleeping, but occasionally woke and stated her head hurt and she was cold. Maggie said she never visited Satterfield alone. Maggie recalled that at the time of Satterfield's admission, it was the peak of flu season and patients were on gurneys in every hallway. Satterfield never told Maggie why Satterfield fell. Maggie said that Satterfield's relatives told Maggie that the dogs tripped Gloria up. Maggie said she visited Satterfield about 5 or 6 times and that Satterfield was always 2 steps forward but 1 step back in her recovery. Eventually, Maggie knew that Satterfield was declining and near death, and Maggie was not surprised by that. When Satterfield died, the family called Maggie to let her know. The family never discussed any legal issues or made accusations to Maggie or Alex. Maggie said that the chocolate lab bourbon was just horrible and always whining, seeking attention, and getting excited. Maggie said it was not uncommon for the 4 dogs who were friendly to visitors to get under people's feet whenever people came to the house. Maggie said that Satterfield knew the 4 dogs and had never experienced any problems with them. Maggie said that Satterfield had no perceived health problems that made her unsteady when standing or walking. I asked Maggie what she thinks happened in the incident, and she believes 1 or more of the dogs got in Satterfield's way as Satterfield was coming up the steps. So Alex's new claim that it was not the dogs that caused the incident is not only calling himself a liar, but he's calling his deceased wife a liar as well. Maggie was there when this happened. And she says that she was awoken by a loud noise. Now these are brick stairs. If someone falls down brick stairs, you won't hear a great commotion, as if you would, for example, with wooden stairs. So what was the commotion if it wasn't the dogs? I have to admit that in the past, and I've stated it on here on my channel, that I was skeptical about whether or not it was actually the dogs that caused the fall. I felt it could have been something Alex made up, but I hadn't seen this actual report before, and I had never heard the statements that Maggie and Paul made. I thought all of this only came from Alex. So I have to admit I've had a little bit of a change of heart here. And it's pretty disgusting that he's now calling Maggie a liar. Now, what does Paul have to say? Let's read on. Paul Murdaugh. Paul is the son of Alex and Maggie Murdaugh. I interviewed him telephonically about 2 weeks ago. His date of birth is April 14th, 1999. He lives with his parents and is a college student enrolled at University of South Carolina, Salkehatchie campus in Allendale, South Carolina. At the time of the fall incident, Paul was asleep in his downstairs bedroom. He heard the dogs barking, which was typical when someone was coming up the driveway. He heard his mother call to him and knew something was wrong. He went on the front porch and saw Satterfield had fallen off the front steps. Maggie Murdaugh was rushing to get a telephone. Satterfield's feet were on the 2nd or 3rd step from the bottom and she was lying on her back. She was bleeding from a head wound and blood was on the brick landing area. Satterfield was awake, making weird noises and not making any sense. Paul did not try to talk with her. Paul remembers that his father Alex arrived and asked what happened, and that Satterfield said something about dogs. Satterfield started throwing up, and so Alex and Paul sat her up while they waited for EMS to arrive. EMS arrived and asked Satterfield her name, which Satterfield was able to give. Paul has not spoken with Satterfield's relatives about the incident, and this was interesting. He did not attend the funeral. So having heard their witness testimonies, I had thought it was odd that the dogs weren't in their kennel. But now hearing about the invisible fencing and that the dogs were barking and that's what the noise was that woke up Paul and Maggie, I have to admit I feel differently about the story. So again, Alex called Maggie a liar. Now he's calling Paul a liar, when they both gave their witness testimony that it was the dogs. So just when you think Alex has gone as low as he can go, you find him going even lower. His wife, his youngest son, born in 1999, dead by his hands, and now he's calling them a liar because he thinks it can save him in court. Absolutely disgusting. There's a lot more to this memorandum. I'm going to break it up here for the sake of time. And we'll be hopefully getting that out to you a little bit later on this week. As always, this is Cassidy O'Connell saying stay well and stay tuned.